Hi, this is Erin, Lacey. Good afternoon if you're on the East Coast, and good morning if you're out west. You are listening into part of the Unraveling the Proposed Borrower Defense Rule webinar series, which our law firm Thompson Coburn is providing. This is the second in 4 installments, proposed changes to the financial responsibility standards, and that's what we'll be focusing on today. So if you are right now listening to the recording, it is possible that law and guidance have changed. Please keep that in mind, and particularly keep in mind that this is a webinar about proposed rules, and we expect final rules to be issued probably in very late October. I mentioned at the top, my name's Erin Lacey. I'm a partner in the higher education practice here at Thompson Coburn. Thompson Coburn is a law firm, so I'm an attorney, and the firm has about 400 attorneys across all its offices. So we're a fairly large law firm as law firms go. The higher education practice, I like to divide it into sort of 3 buckets. We provide regulatory counsel on federal, state, and accrediting agency laws and standards. So that's things like the Title IV federal financial aid programs, Title IX, CLARI Act, consumer information requirements, and, the borrower defense rule and proposed rules like this. We assist with post-secondary transactions, contract drafting and negotiation, all kinds of, different types of agreements, policy creation, and compliance systems design. So people who are trying to get all their policies and procedures in order for, say, Title IX or federal financial aid or something like that will help. And then we represent institutions in student and employee litigation, government investigations, and administrative proceedings, audits, and reviews. So if you have a program review with the Department of Education, or you have some sort of proceeding with your accreditor that jeopardizes your accreditation, you might give us a call and we might help you out with that. Before I was at Thompson Coburn, I spent 4 years at an institution for higher education. It had 24 campuses. It was located here in the Midwest in an online division, and I oversaw their regulatory compliance and government affairs matters. So I've been in-house and very much appreciate that when new regulations like the ones we're discussing today come down the pipe, that is a great challenge for the folks who are on the other side and have to figure out how to implement and operationalize those rules and requirements. And before I was in-house, I spent about 8 years with in the higher education practice of a law firm in Washington, D.C., doing very much the kinds of things I do now. So here's the webinar series schedule. You'll see last week we did the first webinar, which was on the proposed borrower defense framework. This entire rulemaking is often referred to as the borrower defense rulemaking, but it actually has several components. We're going to talk about that in a minute. This week's presentation, we're going to talk about proposed changes to the Department of Education's financial responsibility standards. Here's the presentation outline. I'm just going to touch on the rulemaking very quickly to give you the context, and then we'll talk about financial responsibility, sort of the fundamentals. Then we'll talk about the proposed framework the department is suggesting, and we'll go through some select what I call actions and triggering events, or I should say what the department calls actions and triggering events. Finally, we'll touch on process and consequences and close out, as we always do, with some resources for you. So the rulemaking timeline. There was a negotiated rulemaking process that was announced late in 2015 and began in early 2016. Between January and March, there were 3 rounds or 3 meetings where the department and stakeholders got together, and the department says, we want to create some new rules, and we'd like your input. And so for those 3 meetings over those 3 months, they discussed what these new rules perhaps could look like. At the end of that process, there was not consensus on the rules, which was not surprising, given that many of the people at the table had different views on things. And so at that point, the department was free, as a consequence of there having been no consensus, the department was free to craft the rules essentially as it saw fit, but certainly taking into account a lot of that feedback that it received. On June 16th, those proposed rules were published. On August 1st, the comment period closed. Now, one of the reasons we're doing this webinar series is while the comment period is closed, and by the way, those are all publicly available, so you can go review the comments. There were north of 10,700, but you can pretty quickly find the ones that are lengthy and that were posted by, say, higher ed associations and large institutions. Sometimes it's worth sort of going through those and getting a sense of what the major issues are. But the reason we wanted to do this webinar series is because there is still time to reach out if you have concerns. there's time to reach out to associations or to representatives or others to try to potentially influence the nature of the final rules. Speaking of which, we expect the final rules will come along, my guess is October 31st or November 1st. The department has to, under the HEA, has to get those rules in final form published by October 31st in the Federal Register in order for them to become effective next July 1, and that will be a major objective of theirs. So it is almost certain you'll see that happen. And then, again, the effective date, assuming they hit that November 1 deadline for these rules, or the final version, they would become effective July 1, 2017. I mentioned that, though, the headliner is often the borrower defense piece of these rules, and that's what we talked about last week. There are a number of other concepts that are discussed in different elements of the federal law that are touched upon. And here you see in red financial responsibility triggers, which is what we're going to be talking about today. Next week we'll talk about arbitration agreements. Also, the department revised elements of the rules concerning closed school discharge, false certification discharge, misrepresentation, and repayment rates for proprietary schools. I'll also note that the only piece of this that really and clearly applies only to proprietary schools is that last little piece with regard to repayment rates. Now, certainly there are components of some of these other rules that seem to focus on proprietary schools or would only come into play with the proprietary school, but as a general matter, all of these other elements apply to private nonprofit institutions and public institutions as well. Although, again, with regard to financial responsibility, there's a slightly different set of rules for public institutions. So, what are the financial responsibility fundamentals? It's important to sort of understand what the basic construct here is before we start talking about what the department is changing. To begin and So to initially be certified to participate in the federal financial aid programs and to be able to continue participating, an institution has to demonstrate that it is, in quotes here, financially responsible. Although it's not in quotes on the slide. I'm making air quotes, financially responsible. So to that end, the HEA, and so that is statutory, and the HEA generally authorizes the Department of Education to establish reasonable standards of financial responsibility, right? So schools have to be financially responsible. Department, we are authorizing you to create standards to determine when someone is financially responsible. The Higher Education Act also provides that these standards are supposed to assess whether an institution provides the services described in its official publications and statements, provides the administrative resources necessary to comply with HEA requirements, and meets all of its financial obligations, including but not limited to refunds and repayments owed to the department. So that would be like refunds to students and then repayments returned to Title IV to the Department of Education. So pursuant to this authority, a very long time ago, the department crafted some general standards of financial responsibility for private, nonprofit, and proprietary institutions that are located at 668-171. Now, look, I mentioned a few minutes ago, there's also a slightly separate section of what, or there's a definition of what it means to be financially responsible if you're a public entity, but that is so different. And because it only applies to public institutions, we're really not going to be focused on that today. And all of these revisions that the department is proposing, those really pertain to the financial responsibility standards that apply to private, nonprofit, and proprietary institutions. So if you are a public institution, these revisions, this part of the proposed rule that relates to financial responsibility, for the most part, does not impact you. Right? The standard of financial responsibility that applies to you more or less will remain unchanged. But for private, nonprofit, and proprietary institutions, these are significant revisions, okay? So you've got these general standards of financial responsibility that apply to private, nonprofit, and proprietary institutions. Again, they're located at 668-171, and that's in 34 CFR. So that's Title 34 of the Code of Federal Regulations. The other thing I want to mention is that there is an additional regulation at 668.15 called that refers to financial responsibility factors, and that is active regulation, so those are in effect. In many ways, they are sort of duplicative, and it can be a little confusing trying to reconcile them with 668.171, where you have this other set of financial responsibility standards. What I'll tell you for purposes of this discussion is what the department is modifying And their new framework is all built out of these financial responsibility standards that are at 668-171. So that's what we're going to be focused on today. But if you go look at Title 34 and you go to 668-15, you'll see that there are these additional standards relating to financial responsibility that are tucked into this other regulation. They're just really not implicated in this rulemaking. Okay, so what are those general standards of financial responsibility that are at 668-171? There essentially are 6 of them. You have to have a passing composite score, so your financial ratios must yield a composite score of at least 1.5, and that's also discussed in a little more detail at 668-172. You have to have sufficient cash reserves. So you have to have reserves as is articulated at 668-173, right? And then you get a little more detail there. An institution has to be current in its debt payments. So you could fail financial responsibility if you're in violation of any existing loan agreements or delinquent in certain types of debt obligations. You have to be meeting your financial obligations, which essentially means making all your required refunds and payments of debts and liabilities to the department. Then you have to have a clean audit. So if you have one of your annual audits and you've got a qualified opinion or an auditor expresses doubt about your continued existence as a going concern, that would call into question your financial responsibility. And also, you can't violate any of the past performance provisions at 668-174, and that relates to whether persons or entities that have control or exercise control at your institution may have been associated previously with another institution that owes an outstanding debt to the Department of Education. So there are essentially, right now in the law, at 171, you're talking about these 6 buckets or these 6 criteria. Most of these, and I'll discuss this a little bit more, but you'll notice when the department historically has assessed whether folks comply with these different buckets, it has been in the context of either your annual audit or a program review or some other review, right? So you get your annual audit and there's a calculation of your composite score, and that goes to the department after the end of your fiscal year, and then they do an analysis, right? Similarly, when they would come on site to do, say, a routine program review, they would look at the sufficiency of your cash reserves and things like that. Obviously, the clean audit requirement, for example, would be something that would be evaluated on an annual basis after that audit went in. The other thing is, the department, so talking about sort of process and consequences, if they determine that an institution doesn't satisfy, and this is current, under current law, those financial responsibility standards. So let's say you have a qualified opinion in your audit or your composite score dips below 1.5. They have sort of 3 options right now under the law. The first is they can permit you to continue to participate under an alternative standard. So if you fail one of those standards of financial responsibility that were on the previous slide, you are no longer considered financially responsible unless you choose to pursue one of these alternative standards. But that's not uncommon. There are literally hundreds of institutions that for one reason or another have failed one of the financial responsibility standards and are presently participating under one of these alternatives. So the first is you post a giant letter of credit. The second is you agree to what's called the zone alternative, which typically would involve a smaller letter of credit and some form of heightened cash monitoring. So the department's going to place restrictions on how you move the money back and forth between the department and students. And the other is they could put you on, and this is sort of the most restrictive, what's called provisional certification, which comes with some restrictions relating to your participation in the federal financial aid programs and some heightened reporting requirements. And in addition, you still have to satisfy the requirements under the zone alternative, which is that smaller letter of credit and heightened cash monitoring processes. Now, the department has a couple of other options, too. The vast majority of folks who don't have who fail a standard of financial responsibility are going to end up continuing to participate under one of those things we just talked about, the letter of credit, the zone alternative, or provisional certification. But the department could initiate a fine, limitation, suspension, or termination proceeding under subpart G of Part 668. Or for an institution that is already on provisional certification, they could initiate what I've seen the department refer to sort of as a show cause proceeding. It's a little confusing because obviously creditors use that concept as well, but it's under 668.13d, and it is essentially a process by which the department would initiate a revocation of your ability to participate in the federal financial aid programs, but there is an opportunity for an institution to sort of appeal that revocation. And again, I've seen them refer to that process as sort of a federal show cause process. All right, so what is it that we are proposing, or the department is proposing to do? So the department proposes to revise those general standards of financial responsibility that we just discussed that are in 668-171 and apply to private nonprofit institutions and proprietary institutions, and specifically to include a new set of actions and triggering events. But, you know, I refer to the proposed, here at the top of the slide, the proposed financial responsibility framework, and it's important to understand that that's really what they're doing, is they're sort of repositioning the way this would all work. It's not just a matter of adding a couple of new standards. They're changing the framework and the processes and how this whole thing sort of conceptually would apply to institutions. All right, so you still have those 4 standards at the top. And you'll recall you've seen those before because, and the reason they're blue on this slide is because they're already part of the financial responsibility standards concept, right? The composite score, the sufficient cash reserves, past performance, and the clean audit. But they have added a new concept, which is meeting financial obligations and providing administrative resources. And specifically, the standard requires that institutions, so this is a new standard of financial responsibility, that institutions must meet financial obligations and provide administrative resources necessary to comply with financial aid requirements. Interestingly enough, this wording of having to meet financial obligations and provide administrative resources is closer to what Congress set out in the HEA regarding the financial responsibility standards. So you'll recall a few slides back I said, you know, Congress told the department, go create reasonable standards of financial responsibility, and indicated that they should do these 2 or 3 things. Well, one of them referred to both financial obligations and administrative resources. And that had sort of fallen off when the department did its first effort at these regulations, but now they've put it back in. But then what they've done, and this is very significant, is they've now added a significant new section to the regs, and they've said, okay, so an institution automatically fails to satisfy this standard, the standard of having to meet financial obligations and provide administrative resources, if it is subject to 1 or more of 10 proposed actions or triggering events. So just to make this perfectly clear, what the department says, we're adding a new standard of financial responsibility, you know, and it refers to having to meet financial obligations and provide administrative resources. And then we're putting in 10 triggering events. And if any of these events occur, you are automatically deemed not to be satisfying this standard of financial responsibility. So obviously, it's really important to understand what those actions and triggering events are. So I've laid them all out here. There's 10 of them. This is my Brady Bunch slide, right? In the upper left-hand quarter, lawsuits and other actions. And I'm just going to proceed sort of clockwise. Repayment of borrower defense liabilities, right? So if you have lawsuits and other types of actions, that's a trigger. If you are being required to repay amounts that were forgiven in the connection with the borrower defense proceeding, certain types of accrediting agency actions. If you fail to satisfy loan agreements and obligations, and you'll see that you may recall that used to be a separate standard of financial responsibility in the old construct, and they're proposing to just tuck that in and make it one of these triggers. If you fail the 90-10 revenue test, triggers for publicly traded institutions, so there's a handful of 4 or 5 different events that are specific to publicly traded proprietary institutions. If you fail gainful employment programs at a certain rate, so it's not just any failure, but if a certain percentage of your gainful employment programs are failing, withdrawal of owner's equity under certain conditions, high cohort default rates, and then there's this catch-all 10th category of other events or conditions. Let me just explain some of the color coding here. So the 3 boxes in red, I'm going to talk about those in more detail. It would take 10 hours to go through all of this and talk about all the concerns and the complexities of these various different 10 triggers. But I think you will get a sense. These 3 are significant, and also I think it gives a sense of the types of issues that apply with some of the others. The blue boxes are the ones that apply strictly to proprietary institutions. The other way to think about that is the other 7 apply to private nonprofit institutions as well. Despite the fact that I know there's been a lot of in my view, miscommunication that has occurred and has sort of signaled to some private nonprofit institutions and associations that these rules aren't or should not be of particular concern to them. I just want to make it very clear that, in my view, one, they should be, and two, it is quite clear under the law that all of these green triggers could have implications for private nonprofit institutions, some more so than others. Process and consequences. So the department now, this is more or less what it would look like with these triggers built in. You would have a triggering action or event that would occur, and an institution has to report that event to the department within 10 days of its occurrence or be subject to penalty. An institution would have, in 3 very limited circumstances, and I will talk about those later, an opportunity to provide the department evidence of mitigating circumstances. In other words, trying to establish for them why one of those triggering events should not lead to a determination of lack of financial responsibility. The institution may participate under provisional certification. So you see, I just want to highlight, and we're going to talk about this again, but there's no sort of notice or hearing process here. I mean, the triggering event occurs, you report it to the department. If you're in one of those 3 specific situations, you have an opportunity when you report it to the department to give them some additional information. But otherwise, there's no general mechanism for providing them additional information, and there's no hearing or determination process as to whether you failed financial responsibility. Under the law, the occurrence of the triggering action or event makes an institution automatically no longer financially responsible, right? So at that point, your option is to participate under provisional certification. I emphasize, too, that that's the only option if you have one of these triggering actions or events. So those other options that are available, we talked about earlier, the straight zone alternative or posting a giant letter of credit, which, frankly, nobody ever does. But those options aren't on the table. Under the proposed regs, if you have a triggering action or event that occurs, your only option going forward is to participate under provisional certification, in which case an institution has to provide financial protection to the department, and they have to comply with the zone alternative requirements. So basically, you're posting some sort of letter of credit or providing some other form of surety. The proposed regs contemplate a couple of additional types of surety that could be provided, to include just cash and escrow, and then you're going to have to comply with the heightened cash monitoring requirements that the department comes up with for you. The proposed framework shifts determinations regarding financial responsibility away from audit and review cycles. And this is an important point. I noted earlier, under the current financial responsibility framework, it's not required. I want to be clear about this. It's not required that the department make some sort of determination regarding whether one of the existing standards has been violated. They don't have to make that determination in the context of an audit or a program review. Theoretically, they could just come in, they could become aware of that information and make a determination. But as a practical matter, presently, the way it almost always works is the department becomes aware in the context of a program review or an audit. And one of the reasons that's significant is because that means that institutions also have an opportunity to dialogue when they are going through an audit or program review process. Here, it would shift these financial responsibility determinations to very much to the triggering actions or events. And that's just a matter of something occurring, and within 10 days, you have to notify the department. And then there is no dialogue. It's automatic. Once that event occurs, you are, by law, no longer financially responsible, unless, in one of those 3 specific situations, you can give the department this evidence of mitigating circumstances. So that's a big difference conceptually in how the financial responsibility framework is applied. Points of significant concern. Included among the triggers are many events that represent only the possibility of financial stress. Right? So, and we'll talk about this a little bit later, but the sheer fact that certain things have occurred doesn't mean necessarily that an institution is financially stressed or distressed, right? And a lot of the department, essentially by introducing a lot of these triggers, has sort of lowered the threshold and focused on things that just indicate the possibility of financial stress, which increases the likelihood of a false positive, meaning a healthy institution experiencing a triggering event. So this means, and this is, one of my strong feelings on this point, that materiality and process controls are critical, right? So if you're going to lower the threshold, if you're going to say, well, we're not just going to look at whether significant events have occurred, we're going to start including as triggers events that could just suggest that down the road an institution could become financially distressed, then it's really important that we have a process for evaluating whether or not that triggering event really does suggest some sort of material condition for the institution, and that we have a process for that evaluation. It also calls into question, I should say, whether the proposed framework is in harmony with the Higher Education Act. And what I mean by that is, Congress directed the department to establish, one, reasonable standards of financial responsibility, and then it gave them these 2 or 3 specific ideas, and it said, these financial responsibility standards should be evaluating X, Y, and Z. If you start introducing concepts, triggers, that are only possible indicators of financial stress, I think at some point it calls into question whether those indicators really are reasonable standards of financial responsibility. In other words, if something is only an indicator that there is a possibility that someone could experience a financial issue, is it really a reasonable standard of financial responsibility, or have you departed from what you were authorized to do or what was at least contemplated by Congress? I think there's a real question there. So let's talk about some of the select actions and triggering events. And like I said, we don't have time to go through all of them, but by diving in on just 2 or 3 of these, I think you will start to see why I have significant concerns as to whether or not those critical issues of materiality and process are really being addressed here. So the first I want to focus on in lawsuits and other actions. Now, I'm about to read you a lot of content off of 3 or 4 slides, but I need to go through this in detail to really so that you appreciate the complexity, but also so you see where some of the real concerns are. So the department has said that each one of these things is a triggering action or event, right? And they all fall in the general bucket of lawsuits and other actions. So first of all, any debt, liability, or settlement from a regulatory action that was based on an education claim. So if currently or at any time during the 3 most recently completed award years, the institution is or was required to pay a debt or incurs a liability arising from an audit, investigation, or similar action initiated by a state, federal, or other oversight entity, and you can assume that's a pretty broad concept, oversight entity, or settles or resolves a suit brought against it by that entity that is based on claims relating to the making of a federal loan or the provision of educational services. And I think you can assume that most of what you do as an institution of higher ed relates to the provision of educational services. So if you have if you've had a liability or a judgment, or you've settled or resolved a claim that was brought by one of these government entities, right, then that would be a triggering event, provided that it is either for an amount that is greater than $750,000 or 10% of an institution's current assets. All right. I know that's a lot to absorb, but I wanted to get each one of those pieces. I'm going to go through all of these, and then I'm going to circle back and talk about concerns, okay? So if there was just the initiation of a regulatory suit based on education claims. So the first slide, the one we were just on, remember, now that relates to actual debts, liabilities, settlements. So that's, you've had there's been some sort of proceeding and there's been a determination that you owed some amount, right? But also included among the triggers, if you are currently being sued by a state, federal, or other oversight entity based on claims relating to the making of a federal loan or the provision of educational services for an amount that exceeds the lesser of $750,000 or 10% of your current assets, okay? So this would mean there doesn't have to necessarily have been, the proceeding doesn't have to have ended, and there doesn't have to have been any sort of determination with regard to guilt or liability or anything along those lines. So in this case, the trigger is the mere fact of being sued by a state, federal, or oversight entity, right? And the question is just whether the claim is for more than $750,000 or 10% of your current assets. The initiation of regulatory suits based on claims of any kind. So if you're currently being sued by one or more state, federal, or other oversight entities based on claims of any kind, exceeding those education claims that were discussed in the prior slide, and the potential monetary sanctions or damages from those suit or suits exceed 10% of the institution's current assets. So to be clear, I mean, if you had a group of states or federal agencies or oversight entities, 2 or 3 or whatever, and they simply made a claim of any kind relating to any matter, and the total of those claims exceeded 10% of your current assets, that would be a trigger, and you would automatically no longer be financially responsible. Initiation of suits by private parties based on education claims. So if the institution is currently being sued in a False Claims Act suit, or by one or more private parties for claims that relate to the making of loans to students for the purpose of enrollment or the provision of educational services, it would be a trigger if that suit has, 1, survived a motion for summary judgment by the institution, so it has not been dismissed, and 2, seeks relief in an amount that exceeds, once again, 10% of the institution's current assets. But so you see in this case, you know, we started with actual judgments that were the product of agency investigations or suits, and then we moved to essentially allegations or suits that have been brought but not decided by agencies. And then we had suits that were brought by agencies that related to matters that were unrelated to your educational services. And now we've got suits by private parties based on education claims. Finally, any debts, liabilities, or settlements that exceed that 10% threshold. So during a fiscal year for which an institution has not yet submitted its audited financial statements, because if you submitted your financial audits, if you submitted your annual audited financial statements and you had a decision that resulted in a loss or liability exceeding 10% of your current assets, that's going to be in your financial statements. So what they're saying here is at any point during a fiscal year for which you've not yet submitted your audited financial statements, if the so they don't have to wait till they get the financial statements. If the institution enters into a settlement, has a judgment entered against it, incurs a liability, or otherwise resolved either a regulatory lawsuit, meaning a lawsuit brought by a government entity or oversight entity, or a private party suit based on education claims for an amount that exceeds 10% of the institution's current assets, again, that would be a triggering event. Now, I want to talk about some concerns. I'm sure just by going through those, for many on the phone, there is automatically obvious concern, right? Because the idea here is there is great opportunity for any type of suit that has been filed to result in you're no longer being considered financially responsible. But let's just go through these points of concern. So first, I mean, the fact that the mere filing of a lawsuit would be a trigger, right? Entities, agencies, individuals bring lawsuits all the time. Certainly any litigators on the phone know this, and people who are familiar with litigation and, you know, sort of doing business in America know that institutions are regularly contending with lawsuits. And people can bring suits of all different kinds and make all different kinds of claims. Under these rules, the mere filing of a lawsuit would be a trigger. So it doesn't have to be that there's actually been a judgment or a determination on the merits of the suit or with regard to an amount owed. Qualifying suits could be brought by virtually anybody. So any private party, in addition to state, federal, or oversight entities. And as most people who are familiar with litigation know, any individual can state a claim and seek relief in any amount without regard to how outrageous and unrealistic it may be. So a group of private parties, you know, with a zealous plaintiff's attorney need but file a lawsuit and claim, you know, $500 million in relief, and that potentially could leave an institution no longer financially responsible, right, and automatically. So when suing an institution of higher education, you know, it's easy to state a claim that relates to the institution's provision of educational services. That the department sort of discussed that maybe that's some sort of, at some level, materiality standard, or that, you know, that would somehow winnow out certain types of claims. You know, it is not hard to come up with a reason that something would be part of your provision of education services. But again, there's also even leeway in some cases for claims of any kind, or there's opportunity for claims of any kind to result in a become a financial responsibility trigger under the proposed rules. There's also no process by which to evaluate materiality on a case-by-case basis, right? So, and I'm going to talk about this in more detail later, but the way this works, again, and I've already said this a couple of times, and you'll probably hear it 2 or 3 more times before the presentation is over. there is no process by which, when this type of event occurs, the department goes through a dialogue with the institution to determine the likelihood of a claim being successful, whether it is frivolous, whether there's any sort of merit, or whether it's actually going to have any sort of material impact on the financial responsibility of the institution. Speaking of materiality in a little more detail, the $750,000 threshold also may not be material to the financial health of a large institution. I mean, there are many private nonprofits with billions of dollars in endowments. I mean, these rules do apply to Harvard. Let's just make that clear. They've got a $33 billion endowment, right, or something north of that these days. And if someone or some group of persons successfully made a claim that exceeded $750,000, in theory, they would automatically be found no longer financially responsible, right? In fact, and I've got this in the box, large institutions would be discouraged from settling or resolving claims because remember, if you settle or resolve a claim for something north of $750,000 with an agency that's been brought by an agency or an oversight entity, that's automatically you've triggered. That's one of the triggering events. So a large institution with, $1 billion endowment might prefer to risk a $2 million judgment and to proceed, over settling for $1 million settlement, right? Because if they settle, that's going to trigger potentially a multi-million-dollar letter of credit because the letter of credit's, based on their Title IV receipts from the prior year, and it's 10, 15, 20%, could be more. The department has a fair amount of discretion when settling. In addition, you have to deal with heightened cash monitoring restrictions, right, and being on provisional certification. So they might decide not to settle or resolve the suit. And by the way, I should also take a step back and say the $750,000 is based on the department is drawing that from what is required by or considered by the other agencies to be material in other contexts. Similarly, the 10% is considered by the SEC to be significant enough or material enough to require a filing. But one of the other questions here, or concerns here is, and I don't even have it on the slide, but, because, say, 10% in this case is sufficiently material to require a filing by a publicly traded company, that doesn't mean that it is sufficiently material to endanger the financial health of an institution, right? Those are different standards. And just because something is material in one context, in other words, in one context you're saying what is significant enough to require or prompt a report, right, to a public report. But in the other, you're saying what is significant or material enough to actually indicate a lack of financial health on the part of an institution. Those are two very different concepts, and they're trying to sort of take the standard from one and put it in place in the other, and I'm not sure that necessarily works. In the case of claims filed by private parties, the claim would have to be one that has survived a motion for summary judgment by the institution and has not been dismissed. For those who are not attorneys, that may seem like a pretty significant barrier. In other words, a reasonable standard of materiality. But what you should understand, and I know my litigators on the phone already understand, is that summary judgment can only be granted by a court when there's no genuine issue of material fact. Right? So in other words, they're granting summary judgment because they say nothing here is really in dispute. A plaintiff can easily create disputed facts and thereby avoid summary judgment simply by filing an affidavit repeating their allegations and disagreeing with the view of the defendant. Right? So it's really not much of a threshold. Any creative plaintiff's attorney would be able to ensure or should be able to ensure that you get past summary judgment. Further, and this is another important point, by inserting summary judgment as a standard and using it this way, the department is actually incentivizing institutions to forego a motion for summary judgment and to proceed directly to trial, right? And this is really contrary to the purpose of summary judgment, which is, to the extent it can do so, to weed out meritless claims prior to trial and thus to ease the burden on courts. So, one of the themes here is there are a lot of elements of these proposed rules that create perverse incentives for institutions that the department, I'm not sure they're aware of, or they may just not consider significant enough on balance to sway them one way or another. So this was the next thing. So that was the lawsuits as a triggering action and other actions. And now I want to move on to another one of the sort of buckets, one of those 10 buckets. Remember that big slide, accrediting agency actions. So one of the things that the department in this bucket considers a triggering event is if an institution is required to submit a teach-out plan. So currently or at any time during the 3 most recently completed award years, if the institution is or was required by its accrediting agency to submit a teach-out plan for a reason described at 602-24C1, which I'm going to talk about, that covers the institution or any of its branches or additional locations. So that's a trigger. If you were required for some reason under this other regulation to submit a teach-out plan, that's a trigger and you're no longer financially responsible. So let's look at that regulation. So a teach-out plan under 602-24C1 is required if the department initiates an emergency action or a fine limitation, suspension, or termination proceeding against the institution. Okay, well that's pretty significant. If the accreditor acts to withdraw, terminate, or suspend the accreditation or pre-accreditation of the institution, again, pretty significant. That probably makes sense. If the institution notifies the accreditor that it intends to cease operations entirely or to close a location that provides 100% of at least one program. All right, so hold on. So let's say you're a private nonprofit institution and you operate extension sites, 27 extension sites on, military bases and in other locations and maybe some overseas. And they're all sitting on your eligibility certification and approval report, the ECAR, which the financial aid folks know what I'm talking about, right? So those are approved additional locations. And you decide, because markets have changed or attendance is low or for whatever reason, that you want to close one of those locations and you no longer want to operate it. That is a triggering event, right? You now are required to submit a teach-out under 602-24C1, and you are automatically considered no longer financially responsible. Clearly, this is problematic. Also, a state licensing or authorizing agency notifies the accreditor that an institution's license or legal authorization to provide an educational program has been or will be revoked, right? So that's not that the whole location can no longer operate. That's not that a program across an entire OPID can't operate. It's just the state licensing entity has determined that a single educational programming, whatever license or authorization needed to offer a single program, has been or will be revoked. All right. Finally, subject to accreditor action. All right. If currently or at any time during the 3 most recent completed award years, the institution is or was placed on probation or issued a show cause order or placed on an accreditation status that in the department's view poses an equivalent or greater risk to its accreditation, and the accrediting agency does not notify the department within 6 months that it has withdrawn that action because the institution has come into compliance, again, that would automatically be a triggering event. All right. I think some of the problems here are pretty obvious, but let's just talk about a couple of them. So first of all, the decision to teach out a location, I referenced this a minute ago, may bear no relationship to an institution's financial health, right? I mean, again, I keep picking on Harvard because they got the $33 billion endowment, but my guess is they operate a couple of additional locations out there, right? And lots of large established institutions, proprietary, private nonprofit alike, again, have lots of extension centers and for very good reasons will determine to in an orderly manner, close a location and teach it out, right? Again, it could just reflect market changes. Maybe you aren't getting those enrollments. Maybe the program you taught at that location or the couple of programs are no longer, there's no longer a significant job demand, et cetera. Lots of responsible reasons you could do that. That is automatically a triggering event under the proposed rule. The other problem is institutions, again, we're talking about these incentives that are being created. Institutions would essentially be discouraged from closing locations that perhaps should be retired, maybe even for purposes of improving the financial health of the institution, right? I mean, you might have made a decision to close a location because it's costing you a lot of money and you don't have a lot of enrollments, so it is a smart decision to ensure the financial health of the school. But now if you do that, you are automatically considered no longer financially responsible. You're posting a letter of credit, you're on provisional certification, and you're subject to heightened cash monitoring. Obviously, this is problematic in the extreme. Let's talk about the state decision to revoke a program license, right? It could be that you have requested the revocation of that licensure authorization, or informed the state that you no longer want to offer that program and that they have issued that or indicated that they're going to remove that authorization or revocation at your request. And that's not clarified or dealt with in the reg, that possibility. But the other bigger point is, even if you were to lose authorization to offer a single program, if you offer 100 different programs, right, across 27 campuses, and the state is no longer permitting you to offer one program at one campus, maybe that state has outcomes requirements. So you offer some program and the state says, if you're going to offer this program, you have to show us that, 80% graduate and 70% get jobs. And you're not able to meet the thresholds, and you've worked with the state for a period of 2 or 3 years, and they finally said, you know what, you're not hitting the threshold, so under our law, we're going to have to remove your licensure. And this is one program, and you've got 10 people enrolled in it out of the 13,000 that you have enrolled at your institution. It's still an automatic trigger, and you're no longer considered financially responsible, right? So this gets back to that bigger concern about whether or not the whole construct here is falling away from what Congress really expected, and whether or not a trigger like this that bears so little relationship to the financial health of the institution is really a reasonable standard of financial responsibility. Finally, show cause has not historically been considered a basis of significant concern. As a lot of folks know, accreditors historically have not actually considered show cause a negative action. It's not probation, et cetera. I know there's some discussion about whether that continues to be the case, but in many instances historically, show cause was a tool, right? We said, we don't think you're in compliance. It's unclear to us based on the evidence before us that you can come into compliance with our standards. So we are asking you, to show us that in fact, you are in compliance or can come into compliance with the standards. And show cause orders are issued fairly, I won't say routinely, but it's not as if we're talking about 1 or 2 a year, right? I mean, across all the schools in the United States, you see historically a number of show causes. Many institutions have come off of show cause successfully over the years. By no means does that always proceed or even more often than not proceed to any sort of probation or closure. In fact, I don't have statistics in front of me, but I would hazard that that it is more commonly the case that at least historically schools have successfully come off of show cause than have proceeded to probation or revocation of accreditation. What we also know is that the department historically has not acted on the show cause in and of itself, right? So when someone was merely put on show cause, and again, this could be a proprietary or private nonprofit institution either, if you were put on show cause, historically the department did not take any action based strictly on that fact. And now they're saying not only were we going to act, but if there's a show cause order, we're automatically going to act. Now, there is this carve-out that says if in 6 months the accreditor has notified them that whatever was the basis for the show cause has been remedied, that they will not, in fact, take that action. It's a little unclear as to how exactly that works because you have an obligation to report within 10 days that you've been placed on show cause, and under the law, it's automatic. There's no sort of wiggle room. It's just functionally, if one of these triggering events is satisfied, you are no longer financially responsible. But apparently there would need to be some sort of delay before any sanctions were implemented so you could see if you satisfied the 6-month carve-out. The other concern, of course, is sometimes schools are put on show cause for issues that cannot be resolved in 6 months, or it's impossible for an institution to demonstrate in a 6-month time frame that the issue doesn't exist or never existed, et cetera. So, perhaps you've been put on show cause because you have outcomes, graduation or placement rates, something along those lines that have been deficient or haven't satisfied the accreditor's standards. It may take more than 6 months for you to be able to come up with enough data to calculate a new rate that would show improvement, for example, or that the prior rate or basis for the show cause was no longer warranted. So it's possible the 6 months would not even be enough. One of my concerns, getting back to the whole concept of incentives and perverse incentives, is that accreditors may cease using show cause so freely. If they know that simply placing an institution on show cause is going to automatically force them down this road of no longer being financially responsible and require a letter of credit and all of these types of things, It may be that where previously an accreditor felt that a show cause was a perfectly reasonable mechanism to use to prompt some reform with an institution, they may decide or have to come up with some other mechanism because they don't want these more dramatic consequences to come to pass. All right, the last category I wanted to focus on is, and this is what it's called in the proposed rule, other events or conditions. So under the proposed rule, generally, any event or condition that in the department's view is reasonably likely to have a material adverse effect on the financial condition, business, or results of operations of the institution would or ostensibly could be deemed a trigger. Right, and then they give 6 examples. They say, so these are examples that could be included, but certainly this is not an exhaustive list. A significant fluctuation in the amount of direct loan or Pell Grant funds received year over year, from one award year to the next. Citation by a state licensing or authorizing agency for failing state or agency requirements. So we don't know how significant that citation would have to be. We don't know what type of requirement that we're talking about. And the materiality concept here is just whether or not in the department's view, whatever the citation was or the requirement failed, that it would have a material adverse effect on the institution. Failing a financial stress test developed by the department to determine whether an institution has capital necessary to meet its financial obligations. No financial stress test has yet been provided, but what is clear is that you're not talking about the composite score. The institution or its corporate parent has a non-investment grade bond or credit rating. High annual dropout rates as calculated by the department. And we do not yet have any sort of notion as to what that formula might look like. Any adverse event reported to the SEC on a Form 8K, presumably by a publicly traded company. So the department, for starters, doesn't define the term materially adverse effect, and that's probably by design. They probably don't want to, but what that means is it's very challenging for schools to have a sense as to just how significant one of these events has to be. The proposed rule creates an unworkable reporting requirement. What I mean by that is you as an institution are obligated to report when any one of these actions or triggers occurs within 10 days of its occurrence. But how can an institution know whether an event is necessarily one that the Department of Education would consider to have a material adverse effect? Right? Because remember, that list of 6 is not exhaustive. In theory, anything could happen that the department considers would have a material adverse effect on the institution, and that would qualify as a triggering event, and you would, in theory, have an obligation to report that within 10 days. But, you can't read the department's mind, so it's problematic in that sense. The other thing is even the 6 examples that are given are extraordinarily vague, and the department recognizes and acknowledges that in the proposed rule. I mean, they even say, we understand we're looking for comment. They have solicited comment on how these particular standards or others could be added or these could be refined. But it is disconcerting to an institution when you have standards that are so vague. And as a more general matter, this final Category 10, the extremely sort of vague catch-all nature of it is extremely disconcerting because remember, the way the law works, if the department became aware of an event and simply took the view that that event was likely to have a material adverse effect on the institution or its operations, et cetera, that it could also take the position that you are automatically no longer financially responsible. I mean, this essentially gives the agency a blank check to determine that an institution is no longer financially responsible. It is the non-standard in a sense. And the only thing that is really a standard is the materially adverse effect concept. All right, so processes and consequences. You've seen this slide before. We went through this previously, and really the purpose here, again, of showing it is I want to emphasize that there is no dialogue here that happens between the department and an institution. If a triggering event occurs, an institution is automatically deemed unable to meet its financial or administrative obligations. There's no opportunity for institutions to provide evidence or documentation relating to the merit or materiality of a triggering event or to otherwise be heard. And I use that phrase specifically because the lawyers in the room know and many others know that a fundamental component of due process is notice and the opportunity to be heard. The proposed rule only permits institutions to provide documentation in addition to just the requirement to report to the department that a triggering event has occurred. And, of course, you can try to submit information at that point if you want to. There's nothing in the law that says you can't, but there's nothing that guarantees you the right to do so or that the department will look at what you send in. The only exceptions are these three. So you can, when you report the triggering event, demonstrate to the department that a judicial or administrative proceeding, if you're a public company, was not a material event. To be specific, that the disclosure, the requirement that you had to disclose a judicial or administrative proceeding was not in and of itself a material event. If there was some withdrawal of owner's equity, there are options to demonstrate that that was for particular reasons and shouldn't be considered a triggering event. And finally, if there was a violation of a loan agreement, there's some opportunity to demonstrate to the department that that was waived by the creditor. That's it. Only in those three specific contexts does the department or the proposed rule contemplate that you would provide any type of information other than just notifying them that the triggering event occurred. And even in these three cases, the department under the proposed rule is not required to accept or review evidence provided by the institution or to explain the basis of any determination after it reviews that evidence that a triggering event is indeed material. Right, so you can send it in, and they may look at it, they may not look at it, and they don't have to provide any sort of explanation. They don't have to engage in any sort of dialogue regarding their ultimate determination. Financial penalties, this is also a really important point when we're talking about consequences. Financial penalties for triggering events would be stacked. So let me explain what I mean. And this is a quote from the department from the Federal Register. So this is from the commentary that accompanied the proposed rule. Each of these triggering events would require a form of financial protection, such as a letter of credit of at least 10%. So an institution with and that's 10% of your prior year Title IV receipts, right? So an institution with three triggering events would have to submit financial protection for at least 30% of its prior year Title IV HEA program funds. What it also means in theory, at least conceptually, is that you could end up having to provide financial protection that exceeds 100% of your prior year Title IV receipts, right? Which would, in and of itself, seem out of step with the requirements under the HEA. I mean, the whole point of financial protection, right, is to be able to cover those Title IV obligations. But if you, in theory, had 11 triggering events, you would be required at a minimum to provide financial protection at 110% of prior Title IV receipts, which certainly doesn't seem like a reasonable standard of financial responsibility, or at least I would think there's an argument to be made that it is not. But the bigger concern here is, folks who've dealt with the department in the past typically have become accustomed to the idea that when you have multiple events that occur, the department sort of considers them all together, right? And then we'll come up with a single letter of credit, and if other things happen down the line, they may or may not adjust that single letter of credit. But what they're really saying here is we're taking a much more formulaic view of this. Every time you have one of these triggering events occur, we're gonna stack it. The other thing that's significant is, you could have one event that essentially could be or could work its way into and be characterized as multiple of these triggering events. So you could have something that occurs at the campus, and as a consequence, for example, your accreditor takes action, and you also have some sort of judgment, a single thing where maybe you have some students who sue you as a consequence, and you've got an agency that launches an investigation and asserts some claims, and then in addition to that, you have to make some sort of disclosure, public disclosure, et cetera. And if each one of these constitute a separate triggering event, the consequence is that you could actually have these stacked letters of credit. If an institution is required to provide financial protection to the department, finally, it has to disclose, this is the proposed rule, it would have to disclose this financial protection requirement to prospective and current students, and also post a disclosure on the homepage of its website that clearly identifies and explains the reasons that the institution was required to provide the financial protection. And once more, I know I sound like a broken record here, but this is not just proprietary schools. This would apply to private nonprofit institutions as well. So in the way of resources, again, this webinar series, we're going to do another webinar series after the final rule comes out, where we're going to walk through in detail the elements of the final rule, and we may break that down into more or longer webinars because there's a lot of complexity to this. And then we're going to continue, we're going to continue to publish on a range of topics, but many related, I think, to this proposed rule on our higher education law and policy blog. So please feel free to check that out periodically. That's me. So let's look now at the questions. So one person asked, current assets of an institution, would that be calculated by OPEID, right? Because some institutions within that single sort of concept of an institution, you have multiple OPEIDs. Yes, my expectation is that it would be. The department, for the most part, does everything by OPEID, so when it talks about an institution, that's really what it's talking about. Although in the case of for-profit institutions, there are some that are required to report their financials and essentially their financial health at the institutional level. So essentially the department, though they operate multiple OPEIDs, thinks of that organization, at least when it's thinking about financial responsibility, it's thinking about across all of those OPEIDs. I think there's a possibility that they could look at the picture for all of the OPEIDs in that context. So if you already report to the department your financials on a consolidated basis that goes across multiple OPEIDs, I think it's possible that they would do the current assets analysis across all of those OPEIDs as well. All right, let's see. Can you go back to the state decision to revoke a program license or authorization? Can you confirm this would extend to state authorization, where a state might, for example, revoke an education program because our graduates are unable to meet licensure requirements? You mentioned that this would be an automatic trigger, if I'm understanding that correctly. Yeah, that's right. So one of the things, and this is built into the accreditation triggers, under federal law, and it's under that particular regulation I mentioned earlier, and you can look it up. Let's get to the site here, 602-24C1. Under federal law, you are required to submit a teach-out plan to your accreditor presently. And whether or not your accreditors, incidentally, are currently enforcing these standards or this requirement is an interesting question. But in theory, in order for actually, let me back up even further and really tell you how it works. In order for an accreditor to be recognized by the U.S. Department of Education, right, under federal law, it has to have certain standards in place. One of the requirements, if you are an accreditor recognized by the U.S. Department of Education, in your standards, you have to require that if a state licensing or authorizing agency notifies you, the accreditor, right, that an institution's license or legal authorization to provide an educational program has been or will be revoked, you have to have a standard that says in that instance the institution has to submit to you a teach-out plan. That's actually the way the law works. So this is actually a federal law that applies to accreditors and says if accreditors want to be recognized by the U.S. Department of Education, they've got to include this type of standard. So what you ought to find, if you go to your accreditor standards, you ought to find somewhere buried in those standards a requirement that if this happens, if the state licensing or authorizing agency notifies that accreditor, right, of a revocation of an educational program authorization, that you're required to provide a teach-out plan at least for that program. And what the department is saying in the proposed financial responsibility standards is they just flatly say, and I think this is a mistake, and I know a lot of people commented on this, they say, hey, if you have to submit a teach-out plan because any of these events under 602-24C1 has occurred, then that's an automatic financial responsibility trigger. You're no longer considered financially responsible, right? So the way it would work is if the state notified your accreditor, right, that this had happened, that they were revoking this program authorization, in theory, your accreditor should have a standard in place that says if we get that notice, you've got to submit to us a teach-out plan, right? And at the same time, under the proposed rule, when that occurs and you have to submit that teach-out plan, at that point you would no longer be considered financially responsible because that's one of the triggers, and you would have to report that to the department within 10 days that you had to put that teach-out plan together. Really, the triggering event is the teach-out plan. but that you had to do that. And then, again, there's no dialogue. I mean, the way the law works, the mechanic of the law is that as a consequence, you automatically are no longer financially responsible because you've had that triggering event occur. Appreciate everybody listening in. I know this is a lot to think about. It's complicated. It is in many cases probably disconcerting. I encourage you to try to allocate a little time to think about it. And if you have concerns, talk with your associations, trade associations, whoever those folks might be, and see if there's another opportunity to voice those concerns and potentially to affect the rule before it becomes final. As always, appreciate your time and look forward to next week's session.